Professor Gerald Bamberger, and today we're going to work a simulated multi-state bar examination type of problem in the area of evidence. The problem is problem Evidence1. You can find it on my website, www.profbamberger.com. If you haven't already worked problem Evidence1, why not take a moment, pause this presentation, go over to www.profbamberger.com, spend about 1 minute and 45 seconds working problem Evidence1, and then return and resume this presentation. Okay, I'm going to assume you've already worked problem Evidence1. The correct answer is choice B. The best reason why Donna's testimony should not be admitted is that it goes to the ultimate issue in the case. Now there's a lot to discuss with problem Evidence1, but before we start that, I'm going to very quickly talk about evidence problems on the multi-state bar examination in general. Contracts and property problems tend to be very fact-intensive. Often they include facts that are superfluous. You have to spend a fair amount of time sifting facts. Sometimes you'll get problems wrong even though you know the law because you're confused about the facts. That's less likely to happen in the area of evidence. Evidence problems tend to run shorter. They tend to reward you more directly for your knowledge of the law. Why is this significant? If you know the federal rules of evidence very well, and that's not easy, but if you know the federal rules of evidence cold, you're likely to do very well on the evidence problems because facts won't get in your way. Number one, you're rewarded directly for your knowledge of law. It's nice to be rewarded directly for your knowledge of law. Number two, you can solve the problems very quickly and bank time for those more fact-intensive contracts and property questions. So know the FRE very well. Keep this in mind. Okay, now let's talk about problem Evidence1 in particular. The problem is based loosely on a New York case, a famous New York case, People versus Goldstein. That case also involved a criminal defendant on trial for murder where the only issue was the sanity or insanity of the defendant at the time of the killing. That case, however, was decided on the basis of the Confrontation Clause, using the newly announced holding of Crawford versus Washington, then newly announced. People versus Goldstein was a 2005 case. Crawford versus Washington was a 2004 case. So People versus Goldstein was decided based on the Confrontation Clause. Here, the Confrontation Clause is completely a red herring. Okay, let's talk about why choice B is the correct answer. The best reason why Donna's testimony should not be admitted is that it goes to the ultimate issue in the case. In order to understand this ultimate issue, you first need to understand the concept of opinion testimony, both lay and expert opinion testimony. Ideally, we'd like to have juries form their own opinions. That's why we bring a jury in. Ideally, we'd like to have juries sift through facts and arrive at opinions. It's not really possible to work a trial that way. If you have an expert, you really have to have the expert state his opinion, because a jury would work too hard to try to sift through the facts that the expert used to form the opinion. So we allow expert opinion. At common law, there was still this concern that expert opinion interferes with the province of the jury. So the common law created this ultimate issue objection, to the extent that the expert opinion robs the jury of its essential function with respect to an ultimate issue. The expert testimony is objectionable, or lay testimony as well. If it goes to the ultimate issue in a case, it's inadmissible. The federal rules essentially abolishes the ultimate issue objection. Federal rules will allow any helpful opinion testimony, even as to ultimate issues, with one single exception retained. That's the single exception which we find in our case. Let's take a look at Federal Rules of Evidence, Section 704, Opinion on Ultimate Issue. And remember, at common law, an ultimate issue objection is sustained. At common law, opinions that go to an ultimate issue in the case are inadmissible. Rule 704A. Except as provided in subdivision B, testimony in the form of an opinion or inference otherwise admissible is not objectionable because it embraces an ultimate issue to be decided by the trier of fact. 704A says the Federal Rules of Evidence have eliminated the ultimate issue objection, except for one situation. By the way, the one situation, the original intent was to eliminate the ultimate issue objection altogether. The one situation was brought into the Federal Rules of Evidence under the Insanity Defense Reform Act of 1984 as a response to the situation in the Hinckley trial. Hinckley attempted to assassinate President Reagan. In his trial, experts on both sides said Hinckley is sane, Hinckley is insane. the concern with that type of testimony is the jury now is just engaged in a contest of whom to believe. The jury no longer has the ability to form any sort of opinion whatsoever. So 704B now says, it's the one situation under the federal rules where an ultimate issue objection will be sustained. 704B says, no expert witness testifying with respect to the mental state or condition of a defendant in a criminal case may state an opinion or inference as to whether the defendant did or did not have the mental state or condition constituting an element of the crime charged or of a defense thereto. Such ultimate issues are matters for the trier of fact alone. An expert cannot tell the jury the defendant was sane, the defendant was insane. That is the sole area in which an ultimate issue objection will be sustained under the federal rules of evidence. Let's take a look at choice A. Choice A says the best reason why Donna's testimony should not be admitted is that it offends the confrontation clause of the Sixth Amendment. Sixth Amendment tells us, in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. Now, where are the witnesses against Silverstone in this fact pattern? The answer is, they're not here. We don't have any statements. We don't have any statements made in court, made out of court, that are testimony against Silverstone. So the confrontation clause here is completely a red herring. In the People v. Goldstein case that I mentioned earlier, you had a prosecution psychiatrist who had conducted interviews and who told the jury what the interviewees had told her. Those were statements that the court found were testimonial in nature. They were statements against the criminal defendant. They offended the confrontation clause. That's why the conviction of Goldstein was overturned. Here, there is no confrontation clause issue. Let's look at choice C. Choice C says Donna's testimony should not be admitted because it's based on the hearsay statements of Silverstone's parents, classmates, and co-workers, and is therefore improper opinion testimony. Now, under the federal rules, an expert can testify as to an opinion based on facts or data, even though the underlying facts or data may be inadmissible. Rule 703, bases of opinion testimony by experts, provides for this. Let me quote from Rule 703. The facts or data in the particular case upon which an expert bases an opinion or inference may be those perceived by or made known to the expert at or before the hearing. Here's the key sentence. If of a type reasonably relied upon by experts in the particular field, in forming opinions or inferences upon the subject, the facts or data need not be admissible in evidence in order for the opinion or inference to be admitted. So, if it's normal for psychiatrists to testify as to their opinion based on interviews that they've conducted, even though the content of those interviews may be inadmissible hearsay, the testimony, the expert opinion testimony, is proper under Rule 703. Finally, let's look at answer choice D. The jury will be unable to weigh Donna's testimony unless they are permitted to hear the out-of-court statements of Silverstone's parents, classmates, and co-workers, but these statements are inadmissible hearsay. Now, it may be necessary, under certain circumstances, for the jury to hear the content of the interviews in order to assess the credibility of the expert. Rule 703 provides for a mechanism for doing this. Now, you're not going to find it, it's not going to be easy to get this sort of testimony in, because in fact, if it's inadmissible hearsay, it shouldn't come in. But it can come in if necessary to assess the credibility of the expert. Listen to the standard in Rule 703. Facts or data that are otherwise inadmissible shall not be disclosed to the jury by the proponent of the opinion or inference unless the court determines that their probative value in assisting the jury to evaluate the expert's opinion substantially outweighs their prejudicial effect. So there is an opportunity to admit these statements if the jury really needs to hear them. And I mean really needs to hear them. This is not a 403 standard. This is if the probative value of the statements in assisting the jury to evaluate the expert's opinion substantially outweighs the prejudicial effect, then and only then they can be admitted. The point is, it's not easy to get them in, but the statements can come in so that the jury can hear them if necessary to evaluate the expert's opinion. So choice D is an incorrect answer.